people of the world, let it now be noted that here in our decision, this is what we stand for: justice, truth, and the value of a single human being.
Abby Mann picked out that segment for us to show at whatever time we deemed appropriate, with an idea that that segment of Maximilian Schell's closing argument, Spencer Tracy's reaction to it, is a piece of that movie which speaks to us today. That's Abby Mann's perspective. Does that speak to you in the same way that it speaks to Abby Mann?
You know, I think when Abby wrote the screenplay, we were going through the McCarthy era. And clearly that was a time period where the United States was slowly adopting some of the very tactics of the Nazi regime, and our civil rights were being eroded. And after we emerged from that era, we now find ourselves in this new period of the war on terror. And there are those who have argued that in this war, the law must be silent. There are things going on in our own country today where people are making the argument, the very argument that Spencer Tracy warned against, saying that it is necessary for the protection and survival of our country to put our principles aside. It is necessary for us, for example, to detain people without giving them trials, without giving them rights to have any kind of lawyer, and to put them in detention forever as long as this war goes on. It's appropriate, some argue, for the government to eavesdrop on every American without permission, without a warrant from a court, because that's necessary in order to maybe protect us from terrorism. And it is necessary for the United States to kidnap people and put them in black sites around the world, and to even use acts of heinous torture, which normally would violate the most important treaties of our country that it is a party to, because it's necessary. And I think when Spencer Tracy says a country is more than a rock, it's more than an extension of oneself, it's what it stands for. It's what it stands for when standing for something is the most difficult. That is the lesson of our time. While we're fighting this war on terrorism, we have to remember that we lose the war not by combating the terrorists, but we lose it if we give up all of our civil liberties, the very liberties that make us special as a country. And I do think that we are in a very precarious place right now as a country. Just last Wednesday, I was asked to testify before the US Congress about the US military commissions to prosecute Al-Qaeda. The Supreme Court of the United States very courageously, and this is a Republican-appointed majority Supreme Court, stood up to the president and said, enough is enough. You are not the emperor. The law does mean something, and the Geneva Conventions are important. And the Supreme Court said that these military commissions were violating the Geneva Conventions because they allowed us to prosecute people without allowing them to be present in court, without allowing them to see the testimony against them, without having a right of appeal, the very fundamental things that the Geneva Conventions and our own law require. And so they struck down the military commissions. And then the Congress has the right, if it wants, to reenact the military commissions as is, without making any changes. So they asked me to come in and testify about whether that made sense, whether it was important for us as a country, as an international player, to comply with the Geneva Conventions. And when I was testifying, all I could think about was the words that Abby Mann wrote, the words that Spencer Tracy just spoke, that we just saw. And I think it is extraordinarily relevant to our time.
The complaining party is civilization, which is a quote that I've just probably butchered. But that really comes from Robert Jackson's opening statement at Nuremberg. How much do you sense in your testimony, or even the pervading thinking there, does the shadow of what happened 60 years ago a part of the Nuremberg being the first international military tribunal, the first effort to try to cobble up a group of countries towards creating a rule of law? Is that a factor today?
You know, Jackson was the trailblazer, and he was actually blazing a trail, not that had never been blazed, but against all sorts of obstacles. You had Winston Churchill saying, we don't need any trial, let's just line them up and give them a firing squad. And you had Joseph Stalin saying, that's a great idea, I have 50,000 names of people we'll shoot. And you had Roosevelt agreeing with the two other leaders. And it was Jackson's voice, it was the voice of Truman when he became president, of Truman's Secretary of War at the time, that held sway, but really the embodiment of that philosophy in Jackson's opening speech, which was that what is most important for our country and for civilization is to deal with these issues with the law, to bring these people to a court of justice, to allow them to have rights and to make a defense, even if it's painful, even if Hermann Goering gets to get up and spill all kind of propaganda back to the German people, or fast forward 60 years, Saddam Hussein has done the same thing at his trial, which has just ended in Baghdad. But that is the price we pay for a fair trial for justice, and the reason we pay that price is because when you can prove something in a court of law, giving the defendant the panoply of rights, having the witnesses uphold or stand up to cross-examination, having the evidence be looked at by the defense and scrutinized in court and objected to for every possible reason, that the judgment that emerges from that is a judgment that will be believed ultimately, and that it will withstand the forces of revisionism and will become part of a historic belief. And you know, the famous American philosopher George Santayana said that if we do not remember the past, we will be condemned to repeat the mistakes of the past. Well, in order to remember the past, we have to have a credible record of the past. And so when Robert Jackson said that his main goal at Nuremberg was to prove incredible events with credible evidence, that's why he was doing it.
How did Michael Scharf get in this business? I mean, you are clearly an expert in your field. You're also younger than me. In a time when international law probably was not as a drag for a person who graduates from Duke University School of Law. How did Michael Scharf get there?
You know, I think just growing up, I always had a passion for justice and knew that I would go into the law. And at the same time, I would do activities in high school like Model United Nations, where I really saw the value of working with other countries and collectively trying to solve some of the world's largest problems. So when I graduated from law school, finished my clerkship for a federal appellate judge, and got my job at the State Department, they assigned me to be the attorney advisor for United Nations Affairs. And part of the way I got that assignment was because a lot of people were competing for it, but I said I knew everything there was to know about the UN from all my high school days as a model UNer. And so they put me in there. And it was a little bit just random because it was 1993, genocide for the first time in 60 years had returned to Europe, and they were ready politically to dust off the old Nuremberg Charter and update it and create the Yugoslavia Tribunal. And that mission fell to me. And so I became the lawyer for the US government in charge of putting together the Yugoslavia Tribunal, writing its statute, writing the Security Council resolutions that established it, writing its rules of procedure. And then after I left the US government and became an academic, I didn't want to be one of those law professors that lock themselves up in the ivory towers and just write a lot of articles and books. I've done some of that as well, but I wanted to stay engaged. And very early on, I found myself on a bus at a conference with Richard Goldstone, the former chief prosecutor of the Yugoslavia Tribunal, who had just gotten his new job, and he was complaining that he had no staff and no resources. And I said, well, you know, I've got experience in this area, and I could put my students, an army of students, at your disposal. And so we started doing work for his tribunal. And then when the Rwanda Tribunal came on board, they asked us to do the same kind of thing. When the Sierra Leone Tribunal was created, they asked us to do the same kind of thing. And then soon, these tribunals were asking me to go to various places like Arusha, Tanzania, and The Hague to help train the judges. And then when they recently created the Iraqi High Tribunal, they asked me if I would play a role in that. And that was a more difficult question for me because I personally had been very much against the US invasion of Iraq. I think Robert Jackson would have probably labeled that one of those crimes that he was prosecuting the Nuremberg defendants for, aggressive war. So I was not in favor of that. And I also thought that Saddam Hussein ought to have been prosecuted before an international tribunal like at Nuremberg, instead of just a Baghdad tribunal. But I got this call, and they played on my patriotic duty and also on my need to try to make things better and to bring justice to the world. And they said, look, do you want to sit on the sidelines and hurl insults at us, or do you want to get involved and help make it better? And they gave me an opportunity to help them rewrite their rules, and we actually took all the rules from the international tribunals, put them into the Iraqi High Tribunal statute. Then they gave me the opportunity to shuttle back and forth between secret locations in London to train their judges and their prosecutors, even to do a mock trial with them where we rehearsed all the things that Saddam Hussein might do during the trial to try to sidetrack it, and what they could do consistent with the rule of law to try to rein him in and keep a orderly trial going forward without violating his due process rights. And at the end of the day, you know, the Saddam trial has been a very messy trial. It hasn't gone like I would have liked it to have gone. I think it's gone better because of my participation in it, and ultimately I think that the documentation from that trial will do the same thing that the documentation did in the Nazi trials from Nuremberg. You know, Nuremberg in its aftermath was not readily accepted as just a wonderful thing. Poor Robert Jackson, when he returned from Germany, had to face his former colleagues who said things like, oh, Nuremberg, that was a high-grade lynching party. And another colleague said, you know, that so many principles had been violated at Nuremberg that it wouldn't have passed muster in the United States or any civilized nation. And it is true that Nuremberg was done a little bit differently. It was new, it was novel. But Robert Jackson had the right attitude. He said, mistakes have been made, many errors and missteps must be confessed, but he was consoled by the fact that in the future, when they established new international tribunals, they would learn the lessons from Nuremberg and make improvements. And the same thing has happened with the Yugoslavia Tribunal and the Sierra Leone Tribunal and the Rwanda Tribunal that I've been involved in, and even with the first trial in the Iraqi Tribunal, which has just ended.
As it ended, and as you reflect on what just transpired, what were the surprises to Michael Scharf?
Wow, well, everything was a surprise in that trial. You know, if Nuremberg didn't go quite as choreographed, then the Saddam trial was way off the mark. The first thing we did is we tried to require Saddam to have his own lawyer so that he couldn't represent himself like Slobodan Milosevic had done at The Hague. Milosevic had used self-representation as a way to hijack the trial and make it a political stage. And these trials now are televised, so you know he can talk directly to all of his supporters throughout the Middle East and in Iraq. And we thought if he had to work through a lawyer, then the lawyers could be controlled because there are rules for lawyers. If they act inconsistent with those rules, you can fine them, you can hold them in contempt, you can have them replaced, you can even have them disbarred. But what the judge did, surprise number one, was he said, in Iraq, we do things a little bit differently. This is how we're used to doing things. After the lawyer does his questioning, we always allow the defendant to do his own questioning. And that literally circumvented what we thought we had set up. And so Saddam Hussein had a chance every single day to hijack the trial. And no one saw it coming. And if we had, we would have talked to the Iraqis long and hard about maybe they need to depart from what they're used to. One of the things about having an Iraqi trial is that you're dealing with a different culture, and we look at it through American eyes, but the Iraqis are so different in the way they approach things. A couple of examples. When we were training the Iraqis, at one point, one of my colleagues said, you have to be a pit bull on this issue, and the translator had no idea what that meant. So the translator asked for clarification, and my colleague said, oh, the pit bull is the dog that bites the neck and doesn't let go. And the translator said that, and all of a sudden, all the judges got up and left. And we chased them out of the room, and we said, come back, what's wrong? And they said, well, you can't call us a dog. In Iraqi, in our culture, that is the absolute worst thing you could say about somebody. And we know you probably didn't mean it, but we had to, you know, show our respect for our culture by leaving. So we brought them in, we told them, all right, forget about the pit bull, do you have tree frogs? And they said, oh yeah, we have those kinds of frogs in the marsh areas of southern Iraq. And so we said, well, that's the frog that sucks on and doesn't let go, and that's what you need to be on these issues. They got that. The other thing, though, related to that is the Iraqis love to stage walkouts. And a colleague of mine, Paul Williams, who I work with my non-governmental organization, was at the same time I was training the Iraqi judges, he was in Baghdad helping them rewrite the Constitution. And every single day, a different faction would stage a walkout. And so during the trial of Saddam Hussein, we saw the prosecutor one day walk out, the judge walked out, literally, and they had to replace him, and the defense counsel kept boycotting the trial. And in the United States, we think, wow, this must be a train wreck. But in Iraq, that's what they do. They like to walk out. They also like to be really aggressive and loud and argumentative in the courtroom. And so when a defense counsel starts yelling very loudly at the judge, we think, oh, the judge has lost control of the courtroom. No, that's how it's always done in Iraq. And so one of the big surprises for me in this whole process is that if you're going to have a foreign trial of a major leader in another country, you've got to understand their culture. And until you do, everything about it is going to end up surprising you. But ultimately, from a legal perspective, the biggest surprise was this. The trial of Saddam Hussein didn't turn out to be about witness testimony. It turned out to be about documents. It was really like Nuremberg, where the Nazis had convicted themselves on the strength of their own documents. Turned out in the Saddam trial, there were 6 documents that were authenticated, and ultimately on March 1st, Saddam said they're all true, and he took responsibility for them. This is what they said. The first document said that when Saddam Hussein was going through this little town and these people tried to assassinate him, that he ordered 300 people rounded up as suspects. A little bit like Casablanca, round up their usual suspects. Had nothing to do with who actually was responsible. So they got all these people that had been affiliated with the Dawa Party, which was an anti-Ba'athist political group, and they rounded them up. Where did they put them? They put them in Abu Ghraib prison, somewhere that should be very familiar to Americans now. Second thing, he gave in the second document medals of honor to the people that interrogated and tortured the 300 people, even though there was a document that showed that 1/3 of those people died during interrogation. Now that's very different than how we dealt with our problem at Abu Ghraib. Obviously, we prosecuted the Lindy Englands of the world, these people who were involved in atrocities at Abu Ghraib prison under our watch. We prosecuted them. We didn't give them medals of honor. So that's a document that stood up in trial. Then he has a document where he orders them all tried en masse by his revolutionary court, which is not the ordinary court. It's the specialized court that is politically controlled by him. And they had a one-day trial. They were all found guilty, and they were all sentenced to execution. And the final document is his approval to execute all of them. And those are the documents that are going to probably end up convicting Saddam Hussein in this trial when the verdict is released in 2 months. And no one argued whether those documents were true or not. Instead, what Saddam's argument was during the trial, and what his lawyers ended up arguing, is that a leader has the right to respond to terrorists and insurgents in that way. And they even took examples from the United States and what we were doing in Iraq and in Afghanistan to small towns to root out terrorists as proof that that's what leaders have to do when they're faced with that kind of threat. But what the trial is going to be all about and what the verdict's going to be about is exactly like what we just saw in judgment at Nuremberg. I think that the verdict is going to read very similar to the words that Abby Mann wrote and that were based on the real judge's trial at Nuremberg, and that is that there is a line that is drawn. And even when a country is faced with a terrorist or an insurgent threat, even when it's at war with Iran, or in our case, war with terrorism worldwide, that you cannot cross that line, that you cannot act disproportionately, that you can't take 8-year-olds and 10-year-olds and sentence them to death just because they're part of the usual suspects. Maybe Saddam thought he was sending a signal to other towns around Iraq. Don't rise up, don't try to assassinate me, or you will befall the fate of Dujal, a town that was literally wiped off the planet, the face of the earth. But that is not consistent with the Nuremberg principles, which were codified in the Geneva Conventions, which Iraq itself were a signatory to. And that's what the case is going to be about.
You somewhat telegraphed the verdict. What would be the sentence?
Well, that's a difficult one, because one of the lessons that they tried to learn from other international trials was that if you have one giant mega trial like Nuremberg, and you try to prosecute a Saddam Hussein for things that occurred over a 30-year period of time that might have involved 3 different wars and atrocities throughout his country involving millions of people, that trial is going to last 4 or 5 years minimum. And in the case of Slobodan Milosevic at The Hague, Slobodan Milosevic didn't survive to the end of his trial, and his death erased history from being written. So the Saddam case, they decided they would have mini trials. The first one was the one that they did on the easiest case, the one that they thought was really open and shut. And that's why I think it's pretty clear that he's going to be convicted. But the second trial, which will begin also in a couple of weeks, is the Anfal campaign trial. Much bigger trial because it involves his attacks against the northern Kurds, where he is accused of the crime of all crimes, genocide, a crime which had its genesis at Nuremberg. And this is the worst crime known to human beings. It's the hardest crime to convict for. But he's accused of killing over 500,000 people in the northern part of his country because they were Kurds and using chemical weapons against them. If he is given the death sentence at the end of this first mini trial, the Dujal case, and they execute him at the end of the trial, and he doesn't stand trial for the next one, his henchmen, lower level people, will be tried, and so there will be history written, but the victims are not going to feel like justice has been done. They're going to feel like, and the world is going to feel like the person who was really responsible was not there in the courtroom. The victims couldn't point their fingers at him and, as the French say, j'accuse, which is a very important moment psychologically for victims to get over, and it avoids retribution in the future when they can do that in the courtroom and have that moment. So I do think that the tribunal in Iraq is going to have to try to find a way to keep Saddam Hussein alive for the second trial, which might mean he's not given the death sentence for the first trial, or maybe he'll have it stayed. Now, there are those in Iraq who were so unhappy with the way he was able to hijack the trial that they would just like to see him disappear. And those would be the voices that maybe are among some of the judges, because we don't know, what the judges are thinking on this, that might say, well, let's just, if he's guilty of the first trial, he killed 153 people, that's a mass murderer, he should be executed under Iraqi law. But I personally think that he needs to stand trial for the greater atrocities. And after Anfal, then it's the trial involving the Southern Marsh Arabs, where 500,000 of them were killed. And then you've got also the war crimes that were committed against Kuwait and Iran, and there's several other huge trials that I think are important to have Saddam stand for. On the other hand, you don't want these trials to go on for a decade, with Saddam having his regular TV show, the highest rated show in all of the Middle East. So at some point, I think they're going to have to draw the line.
This is so analogous to what happened in Nuremberg and the subsequent Nuremberg trials, when in fact the top guys were executed or otherwise disposed, then the henchmen, if you will, the next 12, and they lost interest, and all of a sudden they just sort of disappeared. Did you see that same process going on?
Well, one of the things that does happen because Saddam Hussein is in the courtroom is that the media is very focused in, because you never know what's going to happen. It's always an exciting moment when Saddam is in town. And if he is boycotting, or if he's executed and he's no longer there, I think that the international media will immediately tune out. And the Iraqi media probably will lose interest as well. Once they lose interest, then the educative function of these trials will be minimized, because if people aren't watching, they're not learning. So, that's part of, I think, the balance, is you have to sort of survive allowing Saddam to do all of his shenanigans, all of his tactics that are disruptive and trying to derail the trial, because that's the price you pay to get people tuning in. And when they watch, they get a little glimpse of Saddam and his craziness, but they also get a glimpse of the evidence, and they start to learn what really happened under his regime.
In retrospect, would you have felt that an international criminal court would have been the more appropriate function of this trial?
It's a really tough question. Innately, I'm very much in favor of the international tribunals, but when they recently created the permanent International Criminal Court, the world agreed that it would only be a tribunal of last resort. And philosophically, they agreed that domestic trials, when they work, have advantages over international trials. And one of those advantages I alluded to earlier, but it's this, and they learned this in Sierra Leone, because the Sierra Leone tribunal was actually held in Sierra Leone. When you compare the public opinion polls in Sierra Leone about their tribunal to those in Rwanda about the Rwanda tribunal, which is actually in neighboring Tanzania, or in Serbia about the Yugoslavia tribunal, which is way far away in The Hague, what you find is that the Sierra Leoneans feel ownership and keen interest in every little thing that happens in their trials because it's happening in their country. But that the Serbs and the Rwandans feel a real disconnect from international justice. It's far away, it's international judges, they just don't feel like it's their trial. And in some respects, the German people felt that way about Nuremberg. In the aftermath of Nuremberg, there were opinion polls asking the German people, what did you think about Nuremberg? Did you think the Nuremberg trials were fair? And did you think Goering was guilty? And those opinion polls were so unsatisfactory to the American government that they classified them secret and didn't declassify them till just 5 years ago, 55 years after they were taken. What the opinion polls showed were that the German people felt the same kind of disconnect with Nuremberg. They didn't think the Nuremberg trials were fair. They didn't think that Hermann Goering was guilty. And it really wasn't until the Germans themselves had their own concentration camp trials in the 1960s, where they had German judges prosecuting the concentration camp commanders, that you see a real big sea change in German public opinion. So I think anecdotally, what we know is when you can have local trials, that they may have a greater effect than international trials do. On the other hand, that's a big if we can have them. And in the Saddam case, what we saw were 3 defense counsel killed during the trial. And how can a defense team really do a good defense if they're looking over their shoulder, wondering who's going to be the next to be assassinated? Even that story is more complicated than it sounds in the press, because what happened was, at the beginning of the trial, everybody was worried about security. And so the US government and Iraqi government said to the defense counsel, we want to give you our own military contingent to protect you. And the defense counsel said, we don't trust you. You're the enemy, and you're going to spy on us. So the US and the Iraqi government said, well, it's your funeral then. And it was their funeral. 2 of them died in October. Then the judge said, well, that's not going to work. So he brought the defense counsel in and he said, we need to find a way to protect you. And the compromise that was worked out was that they would give them their own money for a security contingency, and they would hire their own guards, their best friends, like rock stars or American athletes might do. And those people had permission to carry large weapons and to protect them. Things were going really well until about a week before the closing arguments in the end of the trial in the spring, when one more defense counsel died. In that case, his rock star, entourage of well-armed protectors wasn't present when he was attacked. And no one yet, to my satisfaction, has explained where they were. There are some reports that he just took the money and didn't hire any guards. So that solution may not have worked either. So the question is, did we really need to move the trial to an international venue in order to protect the defense counsel, or were there ways we could have had this trial in Baghdad and at the same time kept all the defense counsel alive? And that's something I think they're really wrestling with right now.
Have you been in contact with the judges? Do they use you and the Cox Institute for guidance, research?
Yeah, we have a special relationship where they send us issues they want us to work on that are major legal issues that are part of the first trial and the second trial and the third trial. And I have 40 students each year writing long memos on these issues, and we send them out to them. And in addition, a colleague of mine right now, who's part of the academic consortium that I created, is in Baghdad helping them research things that they're going to need to put in the final judgment of the first trial. And so he spent the summer helping them out. There's also other people, not just affiliated with me, but under the auspices of the International Bar Association, that are helping them out. So they're getting a lot of international assistance, which in one way makes this an internationalized domestic court rather than just simply a domestic court.
Are you going there in October to hear the verdict?
No, I think I'll wait and watch it back in the United States. Iraq's a really dangerous place right now. They're really at the verge of a civil war, and so I would much rather play my part from the safety of Cleveland and the other side of a phone line or an email message than try to go there right now.
What other tribunals are you currently involved in?
Well, we currently do work for the Rwanda Tribunal and the Yugoslavia Tribunal and the Sierra Leone Tribunal, which still have about 3 more years worth of work. And in the Yugoslavia context, the 2 most wanted individuals, Radovan Karadzic and Ratko Mladic, are still on the lam. And if they are captured, those trials will be mega trials, and there'll be a lot more interest again, and that will be the end of the Yugoslavia Tribunal. The newest tribunal is the Cambodia Tribunal, and just a couple of weeks ago, the deputy prosecutor of that tribunal and I had a long correspondence where we have been hired to do the same kind of work for the Cambodia Tribunal, which will be prosecuting the killing fields genocide of the Pol Pot regime that we've been doing for the other trials. And then we do work for the Permanent International Criminal Court as well.
You must be having fun. This is a vision, a step on a bus ride with Richard Goldstone, and here it's just step after step after step.
Yeah, I mean, fun is relative. There are nights when I'm reading the documents about what happened and I can't sleep at night. It's terrible, terrible stuff that humans do to each other. But then for somebody who's so dedicated to trying to bring justice to the world, there's nothing more fulfilling than being able to continue to play this role while I'm still a law professor, you know, and teaching my students and lecturing around the world, and still having my hands in the trenches and the nitty-gritty of trying to help make these tribunals work.
What's next for you?
Who knows? You know, I just continue to try to have our operation provide services to all the new tribunals. We were talking earlier in the summer about the new Lebanon tribunal that would prosecute the Harari assassination. I think that's obviously put on hold. The Darfur case is going to be hugely important in the next couple of years, and we're going to want to play a big role in that. There's going to be a mock trial in New York in the fall, and they asked me to be one of the judges of the mock trial so that they can sort of highlight some of the evidence in the Darfur case to put pressure on the UN and the international countries to try to bring these perpetrators to justice. You know, building these institutions is just part of the issue. The other part is getting the political will to get the bad guys. And it's sort of like the international community has this philosophy, if you build it, they will come, you know, to take the expression from that old movie with Kevin Costner, Field of Dreams. And that's not how it works. I mean, just having an international tribunal does not ensure that you're going to have someone like Radovan Karadzic or Ratko Mladic before justice. What it takes is a lot of political will. And the United States has been as guilty as any country of really denying when genocide occurs, of claiming that, oh, it's just a dirty civil war where everybody is at issue, in order to not have to do the difficult things, which is sometimes to put our money or our forces in harm's way to ensure that the people who are responsible for the worst atrocities in the world are brought to justice. So, you know, part of what I do is not just help with the tribunals, but also this public interest campaign to get the kind of momentum behind our own government to make sure that the heat is always on them to be focused on the issue of international justice, because in the long run, the world is better off for it.
One of your mentors at Case Western is Henry King, Nuremberg prosecutor, and very intimately involved with the Rome Conference, part of that Nuremberg prosecutors advancing United States participation in the Permanent International Criminal Court. That's been a mission of Henry's. Mm-hmm. Where does that stand, and where do you think we should be going?
With the Permanent International Criminal Court?
Right.
It's interesting, when Henry spent the summer in Rome trying to get that court to adopt the crime of aggression, he really made a difference in the world. At the end of the Rome diplomatic proceedings, when everybody was still in Rome, Jesse Helms decided to have a Senate Foreign Relations Committee hearing on it. And one of the few people who were still in the States at that time who knew anything about this issue was myself, because I had recently had a small child and was staying at home during that period. So I went to the Senate and testified about the International Criminal Court. If you go back and read my testimony, a lot of what I said ended up being prescient. What I told them was, you can't just make this International Criminal Court go away. You know, basically the United States wants to play the role of the Grinch, you know, from that old Christmas cartoon, and the Grinch couldn't keep Christmas from coming, right? And the United States couldn't keep the International Criminal Court from becoming a reality. So ultimately, despite America's efforts to punish countries that ratified the court statute, 100 countries did. All of our NATO allies did ratify. In North America, Canada to the north, Mexico to the south. You know, we're sandwiched in between countries that have ratified. And when we fight wars with the United Kingdom, if we're not subject to the International Criminal Court, well, they are. So we have to do everything with a mind toward keeping them out of the International Criminal Court. It's therefore having a deterrent on how we engage as well. So that was one of the things that I warned them about, that you couldn't stop it from coming. The other thing I said was, you know, the next time a Rwanda situation comes, you're going to want this court because it could be a very important way of solving a major international crisis. And that happened with Darfur. And what was interesting is that the United States had, in the Darfur case, been the first country on record to say it was genocide, very opposite from Yugoslavia and Rwanda. And once you say something's genocide, a term that was coined at Nuremberg that has its meaning from the Genocide Convention, that's an outgrowth of what Robert Jackson produced, once you say something's genocide, it has a life of its own, a political life of its own. It was very hard then for the United States to say, we will veto at the Security Council the effort of the Europeans to allow the Permanent International Criminal Court to prosecute Darfur. And so what the United States ended up doing was we abstained at the Security Council. We allowed Darfur to go to the ICC. Well, before that moment, the United States had said that the International Criminal Court was an illegitimate court, that it had all sorts of problems, that it wasn't a real court, it was a kangaroo court. Once we allowed the case to go to the ICC, and we did it through the Security Council, now if Darfur and Sudan does not comply, it's the Security Council that's on the line, not the International Criminal Court. It's the competence and legitimacy of the Security Council, which is important for the US to back up. So what happened, I think, to the Bush administration is they like to simplify things. They like things to be black and white. International Criminal Court, bad. You know, local courts, good. And suddenly they can't do that anymore because they allowed the Darfur case to go to the ICC. It all became very complicated, very shades of gray and nuanced. And what that translated in terms of US opinion polls is that the American popular opinion swang very much in favor of the International Criminal Court. They just didn't get anymore why we would be opposed to it if we were allowing Darfur to go to it. I think that's a turning point. I think what's going to happen in the future is the US, it may take us 40 years to ratify the ICC statute, but it took us 38 years to ratify the Genocide Convention. It takes us a long time sometimes to come on board. But in the meantime, Darfur signals that we will use the International Criminal Court. We will allow cases to go to it. A new administration probably will be much more supportive, but even the Bush administration has said things that signal a change where instead of trying to kill the court, fight the court, they're learning they have to live with the court. And living with the court means cooperating with it. And so I think what Henry King achieved and the other former Nuremberg prosecutors who were at Rome that summer and what I was arguing about before the Senate Foreign Relations Committee is now coming to pass. And it's pretty gratifying.
Are we observing now, do we have representatives as there at The Hague?
Yeah, I was just at the International Criminal Court 2 weeks ago because I teach a summer abroad program in the Netherlands. And we had a tour there, we had the Vice President speak to us, we had the Chief of Staff and the prosecutor speak to us. Here's a couple of interesting things. The #2 prosecutor in the International Criminal Court is an American prosecutor. And that's not a coincidence. I think that the ICC is reaching out to the United States. But what it means is that the United States has an American flavor in the ICC, and they're looking out for our interests. They're making sure that the ICC doesn't do something wacky or crazy or politicized against the United States. But also the president of the International Criminal Court is a guy named Philippe Kirsch from Canada. And you know, the Canadians and the Americans, we have our differences from time to time, but we're very similar people. And it's almost like we're all one big country. And to have the president of that court that's making the major policies be somebody who's been from a close ally, who's so close culturally to what we're used to, I think should give us some comfort as well. So the ICC is doing pretty well. It's not going away, and my guess is that the United States will continue to become more and more involved in it and give it more and more support and utilize it because it can actually be a very effective weapon and instrument of our foreign policy, a weapon against our enemies and against people who commit atrocities.
Charles Taylor, what's his status?
Charles Taylor, now that's actually interesting. They were going to prosecute him in the Sierra Leone Tribunal, but he's an escape artist. As you know, at one point he was in prison in Boston, Massachusetts, and he escaped from there. He's got a huge following. He's very politically divisive. And so they decided that they would have the Sierra Leone Tribunal sit up in The Hague rather than in Freetown in his case. And where are they going to sit? In the new chambers of the International Criminal Court. So the ICC is also having this other very interesting effect, and that is that it is allowing the Sierra Leone Tribunal, that the United States very much supports, to prosecute somebody who's of the likes of Saddam Hussein or of Adolf Hitler, a leader of a country that used atrocities as a way of forwarding his own ambitions at the expense of hundreds of thousands of victims.
Your friend David Crane was intimately involved in starting a process which led to what's going on today by signing that indictment. And I know he came here and has told us the story of what a bold move that was, and really without the immediate blessing of the administration.
Yeah. Well, and there's a story where, again, my law school and the program I ran played a big part in what he did. Before he was able to sign that indictment, he had to be sure that the Special Court for Sierra Leone could legally prosecute a head of state, because normally heads of state have immunity. And the question that he asked us to research that year before going up to the indictment was, is the international, or the Special Court for Sierra Leone, international enough to be considered an international court, such that head of state immunity wouldn't apply? And so we gave him a 60-page memo on that with all sorts of examples, and when he did the indictment, he had that in his back pocket. And ultimately the issue went to the appellate court of the Sierra Leone Tribunal. They sided with him, which means that his case could go forward. So, you know, David Crane is a very brave person. He bucked the system. He bucked his masters who had appointed him because they didn't want him doing that indictment. It was the right thing to do, and I was very glad that we were able to help him out in our own way as well.
And literally when that was served, the indictment served, shortly thereafter, he abdicated his position. I mean, so really it was a sea change in international relations.
Yeah,
there's not a rule of law.
And the same thing happened to Slobodan Milosevic. Milosevic was, you know, in power, and even the Clinton administration thought of him after Dayton as the solution, not the problem, in Yugoslavia. And they had talked about, you know, nominating him for the Nobel Peace Prize because of Dayton. And ultimately, a very difficult decision was made to indict him. But once he was indicted, he quickly lost his political support at home. He fell from power. He tried to steal an election, and his own people came out en masse. It was like a Tiananmen Square moment. And the only difference was that his army refused to shoot on his civilians, unlike what happened in China. And he had to fall from power. And then the new government immediately threw him in jail. And then very soon afterwards, he was surrendered to The Hague. So these indictments themselves are politically very important to send a signal that somebody is, you know, that there's a case against them, that they really are involved in these atrocities. It makes them an immediate prisoner in their own country, so they can't travel abroad, which is very hard to run a country when you're just stuck in your own place. Maybe a couple people are able to do it in North Korea, but most leaders do need to go abroad. And then it also cuts out your own political support in your country, because the people in your country know that the world has just indicted their leader, and it's not a political indictment, it's a legal indictment by a court.
You are one of the foremost authorities on international criminal law. You're also one of the foremost authorities on Star Trek. Connect the two for me.
Yeah, actually, I'm not sure I'm a foremost authority on Star Trek, but when I was writing my first when I was writing my first major book about the Yugoslavia atrocities, and I finally finished it. It's like a 3,000-page book with 4,000 footnotes. I was exhausted from the seriousness of the endeavor and just all the work. And so I went on like a late night binge watching the reruns of Star Trek: The Next Generation. And maybe it was because I'd been working on these issues, but every episode I kept seeing international law. And then I realized, no, actually, The construct that Gene Roddenberry had created for this television series made it the only TV series that was all about international law, although they called it interstellar law. There were treaties between different planets, there was extradition law, there was genocide, there was the Prime Directive, which is just like the United Nations Charter that says you're not supposed to interfere in the domestic affairs of another country. So I decided just for fun I'd write a law review article where I would tell people that they could teach international law using examples from Star Trek. And also people would find it fun. So I published that. It became a little cause celeb, a lot of media attention. And then ultimately a book came out about law and Star Trek. And a lot of other people have been writing about law as it relates to Star Trek, but only I had written about international law. And so the first chapter of that book is, The Interstellar Relations of the Federation by Michael Scharf. Anyway.
Well, I suppose to complete the full circle of what we started out today, watching a vignette of Judgment at Nuremberg, one of the actors in that movie was William Shatner.
Oh, that's where you're going. Yes,
well,
that's
where I was going. I just thought about
that's
that.
That's right. Yes, Captain Kirk got his start, his big Hollywood break in Judgment at Nuremberg. He's that really, really good-looking bailiff to Judge Hayward. But ultimately, when you compare what he looks like now in what's his new show, Boston Law. Yeah, it's kind of sad. But anyway, no, he was quite the actor, and he's made a career itself on Star Trek, and he does lectures not just at Star Trek conventions, but more serious about the lessons of Star Trek to our daily lives. So it's funny that a cultural phenomenon like that can become important. But I will, just to make this serious, there are other law professors that write about, for example, taking Shakespeare and using that as a way to teach international law. And I say, well, if you can use Shakespeare's Henry V, why not use Captain Kirk? Certainly the students in the classroom know Kirk a lot better than they know Henry V. So.
This has been terrific. Okay, folks, anybody have any questions or dying to ask? Yes?
Yes, very much on my mind is Quantum and what happened there
Yes.
in Lebanon. And looking at this film, there were two principles, if I understood them correctly. I teach Middle Eastern history. That were made, that someone who encourages another person to commit murder, and someone who provides them with the lethal means to commit that act is an accessory to a war crime. Now, what happened at Quan, and some of you might remember, and we don't know the numbers for sure, we don't have all the facts for sure, so I don't want to make a final judgment on it, but anywhere between 27 and I guess 37, 38 children were killed. Some down to the age of 10 months. Independent reports say that there were no missiles being fired at Israel by Hezbollah, and I have no illusions about Hezbollah, towards Israel, and that these people were targeted and killed. If indeed that is true, if indeed, I'd like to know what the notion of collective punishment is under Nuremberg as it applies to civilians, and if indeed that building was targeted, no firing coming from the building, and children killed, could that ever possibly constitute a war crime, and will the people who allowed that to happen ever see any justice?
That's a really good question. And we're so close to the Lebanese conflict right now. It's dangerous, I think, to pronounce definitively on these issues, especially on a film that's going to be showed in 20 years, but I will try. After Nuremberg, the idea of war crimes was codified in the Geneva Conventions of 1949, and there's a provision in there that says that you cannot target the civilian population, and that to the extent civilians are collateral damage, they have to be necessary collateral damage and proportionate to a legitimate military target or objective. So in the case of Lebanon, I mean, the facts as I understand it is that, there was a kidnapping on the Israeli side. There were shots fired from missiles simultaneous to the kidnapping. The Israelis responded overwhelmingly. The Israelis said that they were going to focus on military targets. And their side of the story is that this apartment building was being used by the Hezbollah as a place to launch missiles. If that's the case, it's the same kind of law that says that under the Geneva Conventions that a church or a hospital cannot be targeted unless it's being used as a place to launch operations. And what happens is the enemy literally takes responsibility for the collateral damage because they've abused the Geneva Conventions by using humans, civilians, as human shields. So if that's the case, then it's a tragedy, and perhaps the Israelis should, if they'd known the intelligence that there were all these children there, they shouldn't have attacked that target. But the question you ask, you have all these hypothetical questions. You say, what if there wasn't any kind of missile? And also, I guess, part of that is, what if the Israelis knew there wasn't any kind of missile, which would mean that they only targeted this to just terrorize the population? Well, if that's the case, and that's all hypothetical, that's a war crime. And Louise Arbour, who is the High Commissioner of Human Rights, and previously had served as the successor to Richard Goldstone as the prosecutor of the Yugoslavia Tribunal, has gone publicly saying that she is concerned with some of the ways that Israel is fighting this, and that her organization is focusing on it so that the Israelis know that somebody down the line is going to be documenting these things, and if there is going to be accountability, it's going to be because people are focusing on these issues. So, I think this is going to be something that is going to be talked about for a while, and as you say, the facts aren't out.
Anybody else?
Yes. I'd like to take this gentleman's question one step further. Those who furnish the means of war are considered accessories, so they can also be guilty of war crimes. So therefore, Iran is furnishing these missiles to Hezbollah through also Syria. So the leaders of these nations can also possibly be found guilty of war crimes. Is that not so?
Well, certainly at Nuremberg, Mr. Krupp was one of the people who was prosecuted because he was using his industries as a war machine to furnish the Nazis with what they needed to commit atrocities, knowing that that's how they were being used. So yes, that principle is out there, but it's always, in the modern world, a little more difficult to employ for geopolitical reasons. For example, the tank-piercing weapons that Hezbollah are using are Russian-made. And so if we follow that logic, then also Russia has to be responsible. In the case of the Rwanda genocide, the machetes and the guns were coming from France, and they have not prosecuted France. And that's not saying that legally they couldn't have made that case, but sometimes you just don't have the political will in the geopolitical situation to be able to pursue those. One of the things I wrestle with when I teach international law, a lot of students say, and the Congress, by the way, said the same thing when I testified last week. They're like, so what if we violate international law? I mean, we're the superpower, we've got the economic and military might, can't we just get away with it? And to some extent, that's true, but there is a price that we pay. And so with my students, I took them to see the International Court of Justice, and we visited Tom Bergenthal. By the way, that's someone you should think about bringing out here because he's a human rights expert. He knows all about Nuremberg. He's a concentration camp survivor, and he's now the American judge on the World Court. Now, Tom Bergenthal is so respected internationally that he ought to have sailed through re-election last year. He also has ruled 3 times against our own country, so he's very independent-minded, and people shouldn't punish him for being an American despite what his administration is doing. But he said that he had an uphill battle for re-election because people were, around the world, countries were saying, why should we elect the United States when it is violating international law so aggressively? And at the same point where he did get re-elected, we've lost other positions. So we no longer have an American representative on the Human Rights Commission, which is a real important thing when we're talking about Cuba, for example. What do we do with post-Castro Cuba? Well, the Human Rights Commission has to play an important role in bringing human rights to that country, and we're not going to be there to play a part. And also on the UN Finance Committee, one of the most important committees of all, the United States lost for the first time ever an election recently. So one of the things that happens is internationally we lose elections. The other thing I talked to, we had the legal advisor to the Hague embassy from the United States, and they were talking to the students, and I asked the same question of him, and he said, in our diplomatic efforts, it used to be really easy because we had the moral high ground. And so yes, we had the money we could use and we had the military that we could threaten, but really it was the moral high ground that got us so much. We've totally sacrificed that. And so now, instead of giving us the benefit of the doubt, we always walk in the room with the doubt. And if any press reports are misleading about what we've done, the other countries are very quick to just assume that it's true because we've done these other things. Then when I was testifying before Congress just about, for example, the Geneva Conventions and why it's important for us to respect them, you could talk very general about how the United States troops are more exposed around the world than any others, and therefore we are the ones who should respect the law because it protects us. But I asked the members of Congress if any of them had any daughters, and half of them raised their hands. I said, have any that are in college? And a bunch of them raised their hand. And I said, do you guys remember the story of Lori Berenson? And none of them remembered the story, but they should have, because what happened was Lori Berenson was a PhD student from MIT, and she went down to Peru to do some research, and for whatever reason, she was accused of being a sympathizer with the terrorist group, the Shining Path. They threw her before a terrorist court, which had the exact same attributes of our Al-Qaeda military commissions. So she wasn't able to appear in court, she wasn't able to cross-examine the witnesses, she didn't get to see the evidence against her, and there was no right of appeal, and they decided she was guilty and put her in jail for the rest of her life. Now, for the first 8 years of the Clinton administration, he tried to get her out of Peru, and they were making some headway. Actually, a lot of people thought that soon she would be coming back. When Bush came to office, the war on terror began, and he put in place the military commissions. My understanding is that he tried to make initial efforts, not him necessarily, but diplomats on his behalf, and the Peruvians said, look, what we did to Lori Berenson is the exact procedures you have in place when you're fighting your war on terror. Why should we release her when you don't release all yours from Abu Ghraib or from Guantanamo Bay? And so we don't even talk about that issue anymore. And I told the members of Congress, look, violating international law has really personal consequences to Americans when we travel abroad and when your kids travel abroad. And we have to remember that. Okay, so what happened at Nuremberg is that Robert Jackson fought to include not just war crimes and crimes against humanity, but the crime of aggression, or crimes against peace, which was basically defined as invading a country without provocation, without justification, which Hitler did. And he thought he was outlawing war. He thought that was the most important thing that came out of Nuremberg. And there's some really wonderful language from the Nuremberg judgment on that. In a way, he succeeded, because the UN Charter, which was negotiated after the Nuremberg Charter, codified that principle in Article 2, Paragraph 4, which says that one country can't invade another, with only two exceptions. One is if the Security Council authorizes it, and the second is if it's in self-defense. Now, the US has been accused over the years of aggressive warfare. And one of the reasons the United States has been against the idea of including that crime in the modern International Criminal Tribunal statutes is because the US is afraid it will be accused of that crime. Things like the invasion of Panama, the invasion of Grenada, Vietnam. And so, therefore, the US was against inclusion of that. In the International Criminal Court, they made a compromise where they said we won't include it right away, but when we have our First Amendment, that's the first issue we will discuss. And what they're trying to do is come up with a definition of aggression that will meet modern international standards of due process and a triggering mechanism. Maybe it'll have to be the Security Council that approves the court or something like that, or maybe 3/5 of the United Nations General Assembly, so that it's not something that it's an issue that has such a political component that it's difficult for countries to just give that to a court to decide.